Where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, everybody. Happy Thursday. Another day in As the Delphi World Turns. As I was getting all of the things together for what I was going to do this live on, we got a response from Cara to the Attorney General and to Judge Gull. So I'm like, well, I guess that's what we're going to do today. We're going to talk about what they have to say. So let me say hello to everybody. Hello, everybody. Hi, Janie Lane. What's up? Journey takes a trip. Hey, Shaz. Yes. Hi, Queen Elizabeth. Hi, sweet dude. Another YouTuber. Got the breaking news scoop. I just got home from picking up kids, and it's not a scoop. It's a paperwork. What do you call it? I'm so glad to see you. It's okay. If you want to watch them because they were started before me, I'm okay with that. I don't know who it is, but do it. Do it. Hi, Rexy. What's up, Ashley? Hi, Missing Unsolved Crime. Lilith. I know I can't catch a break, Kate. I can't catch a break. I can't let it go anyway. So, I mean, it is what it is. It's just, this is where I'm stuck right now. And eventually I'm going to be able to forge through and do other things, but not today. Hi, Digital. Hi, Mindy. I think I said hi to Ashley. Hi, Ashley, if I didn't. Maligator. Emily's mom. How was the lasagna? Hybrid Pisces. Doing cartwheels like, where? As the world turns. The Rockaways. Hi, Marshall. Hi, Grace. What's up, Angela? Hi, Nancy. Big G. Hi, Dina. Hey, Mandy. Hi, Music City Mom. Hey, Teresa. Inspector Gadget. Hey, Ariel. Ramblin' Rome is in the house. Peppermint tea. It's my favorite because I love peppermint. Hey, Journey Takes a Trip. I love the name because I want to go on a Journey Takes the Trip. Okay, so we're just going to get right into it because that's just what we're going to do today. You guys remember, we just read through the Attorney General's response, and then Judge Gull filed her response, and this happened with the first writ, and this has to do with the second writ, the original action that was sent to the Supreme Court. So this has to do with number 2. So we did something very similar with writ number 1. When she put in her response, Cara requested the Supreme Court to allow her to respond. So you have to, let me pull that up first. You have to request to be able to add your response. And then the Supreme Court will have to go in and say, yes or no, we're going to allow this response. They can say no, but the response is obviously already prepared. And on the first writ, the Supreme Court did order for the response to the response. Remember, it gets more confusing because now this is the relator's response to Gull and the Attorney General's, well, Gull's response and the Attorney General's, whatever you want to call his. What's up, Art of Deduction? Hi, I plead the fifth. Can't stop with this guy. I know, it's just, today is the day. No, today's not the day. Today's the day. Today is not a day to be excited about because it's not really the day. That was delicious. I bet it was. I bet that lasagna was delicious. So damn jealous. Hey, Percocent. I think I'm saying that right. Gam. Why do you always think of Garfield when you hear lasagna? Hey, Crystal. Did not see it. Which part? High Crime Curious. What's up, Polygraph? So, here we are. Let me get this on here for you guys. Blow it up. So this is, yes, new docs. Went to go pick up kids, and then documents have to come in. That's just how it goes. So this is, Cara and team are requesting to go to the Supreme, or to for the Supreme Court. Oh my gosh, I'm going to start that whole sentence over again. Cara and team are requesting the Supreme Court to allow them to respond to Judge Gull's and the AG's responses. And that's what this is. This is the first thing that we're going to look at. What's up, Bonnie? Hey, Alley Cat. Hi, Tracy. Yeah. Hey, Jen. So let me make sure you guys, it's big enough for you guys to see it. Well, we just got here. We just got here. Moxie! Okay, so relator by counsel respectfully requests that this court allow the relator, which is all Cara and her team, more specifically, it's actually Richard Allen. So allow the relator the opportunity to respond to both respondents and the Attorney General's objections to relator's petition for a writ of mandamus. In support of this motion, relator states the following. Number one, the Indiana original action rules do not expressly provide a relator the opportunity to file a response to a respondent's objections. Nevertheless, the court has granted a relator leave to file a response in prior original actions. Very true, including the first original action submitted to this Supreme Court by Cara and her other attorneys. Number two, a response is warranted in this case for three reasons. First, the Attorney General has asked for certain portions of relator's record of proceedings to be stricken. Did he? I guess I don't remember that. Second, the Attorney General and the respondent both object to relator's petition for a writ, but on somewhat contrary grounds. Both parties argue that removal of counsel is a matter within the trial court's discretion, a position which relator disagrees. But the crux of the Attorney General's objection to issuance of a writ is that there is not a sufficient record in this case to review the issue. The crux of respondent's objection, however, is that the record is sufficient to support respondent's removal of counsel. Okay, so let's break that down for just a hot second. Hey, the Unraveling. What's up, party people? It added 12 years onto my life. It's like a back and forth. It's like pull and oh gosh, like what are we doing? Hi, Sleepy Goosey. What's up, Trinity? Hey, Tomboy. Hey, Coach Kev. Here to understand this, I'm trying to figure it out. I'll figure out all the legalese. It gets confusing specifically with this stuff because there's so many like response to relators and respondents and who's the who and the what's the what, and so it makes it more confusing. So to break down this really quick, so what they're saying here is the Attorney General and Judge Gull both responded, right? We read through those. In that, they contradicted each other because they said, if you remember, we talked about this too, the Attorney General talks about that he essentially wants to agree with Judge Gull. He wants to be on her side. He knows that she has the right to do what she's doing, but he can't fully support it because the record isn't clear enough to support what she's doing for him to know whether she's doing it the right way or not. So that's really what he kind of argues. And then she comes in with her response and says, look, all of these things that they've done, it's very clear and they deserve to be removed. And that's just the bottom line of it. So they contradict each other because he's over here saying, I don't really know. I mean, she does have the right if what she says is true. And she's saying, well, what I say is true, so I have the right. Now, this was another big thing that popped up, and we talked about it when we were reading through, and I think it was Ariel that was actually posting the case. It was, what was it, Ariel? Indiana versus Jones, I believe it was, or Jones versus Indiana. It was one of those. But that was the case that they both kept citing in their responses. Well, the irony behind it is the Attorney General actually says that this whole situation does not require a writ of mandamus, that it should have gone to an interlocutory appeal and followed the process that way. And they used the case citing where another attorney was thrown off of a case, but that attorney, it was State Jones versus Knox Superior Court. Thank you very much. Here it is right here. Yeah, State versus Knox. But in the case they're citing, that case was actually seen and determined by the Supreme Court. So even though it was denied, it was totally separate situation, totally different, grounds for why it was denied than what this one would be. It's interesting that they try to use a case that was decided by the Supreme Court to show that this case should not be decided by the Supreme Court. Do you guys see what I'm saying? Like, how does make that make sense? So it was actually decided by the same court that they're saying shouldn't be seeing this one. So it was a really bad argument on their part. But so that's the, I hope that made sense. If somebody tell me if that doesn't make sense, I'll try it a different way. Finally, since relator filed this petition or filed his petition, respondent has produced a transcript of the October 19th in-camera proceeding and ordered the trial court clerk to make several filings publicly accessible. Relator had not had access to the in-camera transcript and one of those filings until it was made publicly available. The new filing was a report filed by the Carroll County Sheriff in June of 2023, which is relevant to respondent's objection and is included in the supplemental record of proceedings relator is filing contemporaneously with this motion. Relator therefore files this response asking that a writ of mandamus be issued. Okay, it makes sense? Okay. The circumstances of that case, to try to sum it, because I don't want to get too confusing with talking about too many cases at the same time, because that'll really make things wonky. But essentially, what happened was the defense team wanted something, a deadline or something to do with some DNA evidence, and they essentially told the judge, either give us what we're asking for or allow us to withdraw. And the judge said, no, screw you both, basically, and I'm going to remove both of you. So they were like, you can't do that. We're going to go to the Supreme Court and show that you can't just remove us or disqualify us. And so they went, and then the Supreme Court was like, nah, dudes, you guys literally said if she's not going to give you what you want, or whatever the judge was, if the judge isn't going to give you what you want, then your alternative was to be gone. Well, she's not giving you what you want, and look, now you're gone. But it didn't go the way they wanted it to, because they wanted to withdraw, and she disqualified them, or that judge disqualified them. So they were denied because they wanted to withdraw or basically force her hand. So different because these guys did not want to withdraw. But the irony once again is still that they used a case the Supreme Court actually decided to say that the Supreme Court shouldn't decide this. Yeah, it was definitely different. Okay, so we can go through. We'll just take a quick peek at their supplemental report. Just see what she threw in here. So this is the transport order for the June 15th hearing. The sheriff returned. The writ came to the hand. Okay, so this is going to be about Robert Batson. We're going to come back to this, so I'm just skimming it to see like kind of where everything is. Okay, so not much, but they needed to put some things in there that were important that they didn't have access to. A quick, yeah, that's what it's called now. It's called, that's a quick peek put together. That's a quick peek. Yeah, Sleuthy Goosey, I'm about to read it. I just read her request to the Supreme Court to allow her to respond. That's all I've read so far. Yeah, that's a quick peek put together. That's how we do it around here. We're trying to get through some stuff. We're just gonna put the words together. We're making our own language. Hi, Sleuth Investigate. Okay, so now we'll just go over to Cara's response. So the relator's response. So remember, this is not on the record yet. It has to be approved to be added to the case. They approved her last one for the first writ. I would be surprised that they wouldn't approve this one, but she still has to ask for permission. So that's where we're at. Oh yeah, I got it, girl. I got it. Hi, Delina. It's okay. I see no reason they won't approve this response. Yeah, it would not make a lot of sense if they didn't. As little as Gull would have had to do it properly, she still couldn't be bothered to do it. She now gets to spend 6 months back and forth with the Supreme Court. Essentially, yeah. She could have just done it the right way, but but then you have the ones that feel bad because they think that she was doing them a favor. She was doing them a favor. Who pays her attorney's fees? She does. She has to pay her attorney's fees. That's okay. I think she can afford it, Idaho Charlie. I don't think we need to start a GoFundMe for her yet. I have to start all over with a live to the catch up because I'm so confused. I'm on lunch break, but I'm going to restart this live. Okay, Caitlin, you're working a lot, girl. All right, so we'll make sure I'm all caught up on you guys, and then let me turn this off so you guys don't have to stare at the side of my face while I read to you. Okay, so her table of contents, and here we are. So this writ is the only remedy. Any trial without Baldwin and Rosie, Rick's counsel of choice, would be merely for show. Only 2 attorneys can be ready for a speedy trial and carry out Rick's well-developed trial strategy. And only one court can grant that relief, this court. If action is not taken now, Rick's trial will be delayed longer, and even more public resources will be spent. But more importantly, the public's trust in the judiciary will be permanently oh my gosh, maybe I shouldn't read anything today. Will be permanently undermined while the world watches. A little guilt trip there. Hey, Skip. Hey, Mar. Julio Suave. An appeal is inadequate. Well, I don't know how they would be able to appeal when she wasn't putting anything on the docket, and anything that they tried to put on the docket, she said, sorry, guys, screw you, you're not part of this anymore, and we're going to have it all removed. But don't use specificity me. Hold on, guys. Hold on. Middle child wants me to take her to Starbucks. I'm like, it's kind of in the middle of something. Can't really go to Starbucks right this second. But oh, see, I'm talking about Jones down here anyway. So this court routinely relies on its original jurisdiction to address claims where attorneys have been or should have been disqualified. See all of these, and here's one of them that they talk about. And the respondent and the attorney general do not dispute this fact. The unlawful disqualification of a lawyer strikes at the heart of the public trust in the integrity of the judicial process and requires this court to invoke its inherent authority to supervise the conduct of lower courts. Respondent severed the attorney-client relationship on her own sua sponte, remember, motion and over Rick's objection. Respondent misapplies state versus, here we go right here. So Jones versus Knox Superior Court, they misapply it when she argues a writ is inappropriate. In Jones, this court denied a writ of mandamus and prohibition petition that challenged the court's decision to disqualify criminal defense counsel in a murder case. There, the attorneys initiated their own withdrawal. See, I tell you guys all the time, I shouldn't even answer questions because I just say I need to read, or I shouldn't even ask questions because I just read further and there's the answers. There, the attorneys initiated their own withdrawal. This court did not deny the writ for failing to have a clear, unequivocal right to reinstatement of counsel, but because this court will not countermand the trial court's ruling that placed defense counsel in precisely the position their motion indicated their willingness to be. That's quoted from that. This court did not doubt for a moment that a court-initiated discharge would properly fall within the court's original jurisdiction. This court is generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. Here, respondent made it clear that she was discharging attorneys Baldwin and Rosie on her own motion, regardless of how defense counsel proceeded or what the prosecutor wanted her to do. Respondent initially suggested defense counsel just, quote unquote, read between the lines regarding what she was saying. You're a lawyer. Read between the lines is what you do for a living. I use that one still. Eventually, she made it clear that she was unequivocally severing the attorney-client relationship, and there was no situation where attorneys Baldwin and Rosie could proceed with representing Rick. This is part of that transcript, so I'll reread it though, just in case anybody hasn't heard it. Mr. Rosie says, so basically what you're saying is you guys either quit on your own accord or you make me fire you? That's what the court, no, I'm saying to you that this is what I plan to say in court on the record when we convene at 2:00. Mr. Rosie says, well, so is the culmination of that you're removing us from the case? The court, I will, based on what I've just shared with you. Oh, Caitlin, thank you for joining, honey. Unsolved Crimes Uncovered. God, I'm just loving your channel. She put out a video yesterday you guys need to go watch. So again, one of the mods share her channel. Unsolved Crimes Uncovered. It's just so fact oriented and just straight to it. No fluff. Hey, Kel. Yeah. You got to read between the lines if you're an attorney. That's how you do it. That's how you do it. You got to read between the lines. That's your job. So this is just, just even rereading it, I'm just like flabbergasted at it. Mr. Rosie, okay, well, just want to make sure we're the court. And I'm just giving you the opportunity to have a conversation, which, how do you want that to go? I don't want to do this. I don't want to do this, but I will if I have to. You should just read between the lines. You're an attorney. That's what you do for a living. But then she says, so basically you're saying quit or you're going to fire us. No, that's not what I'm saying. I'm just telling you that I'm going to go out there and read this if you don't quit. He's like, so you're removing us? Oh, and she's like, oh yeah, I will, based on what I just shared with you. But she says no, that's not what she's doing. And then she's like, no, I'm just saying, like, you guys just need to have a conversation. That's all I'm saying to you. Just have a conversation. I'm not telling you that you're going to get fired, but I'm just telling you that you're going to get fired when I go out there. That's exactly what she's saying. Respondent acknowledged that the prosecutor had initially asked to remove defense counsel during an informal phone call, but she concluded that she did not need a formal hearing on that request or even a pleading on file because she was acting to sever the entire defense team on her own motion. Mm-hmm. So Mr. Rosie says, I am extremely, I'd say frustrated. It's probably a soft word. He's probably going, I'm fucking pissed with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think it's improper. And that's where I am. And that's my position. She says, well, I think we talked about when you, the prosecutor, asked for a disqualification, and I indicated on our phone conversation I'm inclined to do that. Says it was a phone conversation that was not on the record, and then some follow-up emails. And she's like, yeah, that's true. That's true. You're right. Yeah, it was a phone conversation that was not on the record. But it's just your job. Read between the lines. Okay, so footnote. The affidavit from attorneys Baldwin and Rosie and the email correspondence between the parties provide helpful context for this discussion and eliminate any ambiguity regarding who and what the judge is referring to here. The Attorney General has objected to these exhibits. Oh, that's what he did once, Stricken. That's right. The objection to these two exhibits, L and V, should be overruled. To the extent that any of the facts recounted above are derived from the portions of the record to which the state objects, they are not pertinent to the legal issues here and simply provide context. Justice Shepard, considering affidavits from defense counsel and various other letters. So these are just what they're citing. This is what she's citing to make it so that the exhibits L and V that they're asking to be stricken are actually, that objection's overruled. And then exhibit U is the affidavit of Westerman, which was filed in the proceeding below on October 18th, 2023. Okay, so she's like, yeah, true. That's true. We weren't on the record, and there was just some follow-up emails. And he says that there's an informality to that. She's like, yeah, that's true. Yeah, you're right. Uh-huh. He says, and you also said that you hadn't even done any research, and you hadn't, had time to talk to your senior judge and all these other things. And the prosecutor hasn't filed a pleading with the court either. She says, no, I'm doing this on my own motion. Attorneys Rosie and Baldwin offered an alternative to avoid eliminating the entire defense team and to ensure some semblance of continuity of counsel and efficient administration of justice. But respondent flatly rejected that request. Rosie says, is there a scenario where the court would accept if I stayed in the case? I'm a team player, and I'm not the kind of guy that just bail out on somebody just for the sake of doing it. But I think it's obvious that, and Attorney Baldwin could speak differently, but I'm not as connected to some of, this most recent circumstances as Baldwin is. Mr. Allen is in a situation where he's going to have counsel that's, if he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment rights matter. And I'm probably the one that can at least move this thing forward with some sense of judicial economy. I don't like it, and that's not what I intended to do when I came here today, but that would be kind of worst case scenario on our side. So is that an option that the court would entertain? No, that's not an option that I would entertain. No. Attorney Rosie and Baldwin spoke privately with Rick and returned to chambers to advise the judge. Rick objected to severing the attorney-client relationship. He wants us to continue with his representation. Attorneys Rosie and Baldwin suggested the respondent hear this directly from Rick. Mr. Rosie, I think it's appropriate that the court let him speak into the record his thoughts, unless the court just accepts that as notice that those are his opinions. They expressed concerns that Rick's rights against self-incrimination would be prejudiced if he was forced to speak on the public record without counsel. So they suggested bringing Rick into chambers. It seems a little bit of a difficult position to put a man who's accused but not been found guilty. Put him in a courtroom and have him, have to speak in the circumstances with 15 minutes notice. I think it's appropriate that the court let him speak into the record. The judge declined to hear from Rick directly because it would make the DOC uncomfortable and because she would not be comfortable having him in her office. The judge removed attorneys Rosie and Baldwin over their and Rick's objections. Yeah. See, dude. Rosie was a very quick thinker, and it just made me so much more impressed with him than I was just like, yeah, like he went in there, he made sure to say all the things that were important to be said, made sure they were on the record, and then went home or went to his office and wrote the motions that he did. The one that was the motion for him to continue his representation, her motion to disqualify. I mean, he was on it, and he wrote it all down as fast as he could so that he had the most accurate memory of it. And then she tried to deny allowing them to have the transcript. She didn't want to give it up. She did not want them to have it. And then she's like, oh, they could have asked for it themselves just by doing exactly what, Cara did by going on there and just doing a limited appearance. Well, no. Because anything they put on there, you got rid of because you didn't want them around. Would you have allowed that? You think that they would have gone in there and she'd been like, okay, well, here you go. Here's the transcripts. Okay, so respondent had an absolute duty to refrain from severing the attorney-client relationship. Not a single Indiana case has tolerated similar behavior from a trial judge. The other thing here is this just brings, I got to back up to this one still. This just brings me back to my whole thing. Why not just tell them? Why not just tell them? Make it very clear. Why not call the hearing for what it was? Why let it stay like a status hearing that was going to be to update, on other issues that had recently arisen, is how she put it. Why not just say, hey, this is it. We're going to have a disqualification hearing because that's what I'm leaning towards. We're going to get it all on the record. Bring what you got. Convince me otherwise or whatever. I just think that, why not just set it up to do it the right way? Just tell them, hey, the 19th, this is what we're doing. Come in, be ready. And even if she let I think that the cameras probably shouldn't have been there because it's more of the technical, the judicial side of things, but that's what we're supposed to see. So then it's like, okay, I don't even care if the cameras were there at this point. Even if she did that, but just give them the notice, let them go in, have the entire hearing, let Rick sit there, talk to Rick, directly to him. Do you understand what's happening? Do you want this to happen? What do you wish to happen? This is your counsel. This is your trial. These are your constitutional rights. What do you want to happen? And I know people are like, all the ones that are already ready that he's guilty and it's done are like, who cares? Hold on a second. Give me 1 minute. Yep, it was a tiny human. It was. Something happened to a paper that he drew on yesterday, and life is over as he knows it. So, okay, where were we at? Oh, I was just saying, I don't know why she just didn't go through it it just doesn't make sense to me. Why not just follow the proper procedures, have them there, have the hearing, talk to Rick Allen, see what he wants to do. I mean, you care more about what freaking McClellan wants than you care about the person who's actually on trial. It's just so frustrating to me. All right, let me see what you guys are saying. Then I'm going to read the next part. Ariel, they can't prove the case. They expected Ari to flip and her plea. Well, and I think that's really where they're going to be pushing now. That's I just have that feeling that these attorneys are going to push him to take some form of plea. and get this over with. I think that I know that that's like unpopular in the big thing, but like, how in the world he was not ready? How did he expect to get Luttrell up to speed by January? He just brought in a special prosecutor on October 19th. How in the heck did he expect that person to be able to prosecute this case come January? Hold on. Sorry, guys. Okay. Sorry. Okay. Yeah, he's spending too much time, investigating leaks for 17 days. But how is he going to get him up to speed to be able to help with this trial? It's not possible. And what happened to Shane? Where's Shane Evans? Wasn't he supposed to be there? Jen, thank you for joining. If proper procedures were followed by an impartial judge, the case would be thrown out. Just my opinion. Digital, yeah. We want to go that far with it, yeah. It very well could be. But we don't know. We don't know what else that they're bringing to the table yet. Because right now there's, quote unquote, enough probable cause to continue to take him to trial. But I cannot come up with a reason that guy would have all of those people sitting there and ready to testify about a fucking leak that the more I continue, I'm going to tell you guys, this is a total side conversation. I'm going to tell you guys, I keep looking into this leak situation because it's really bothering me. And I'm going back to some old lives. And I'll tell you right now, people were talking about these crime scene photos back in January of 2023, back in December of 2022, on live streams, that there was crime scene photos of the girls that were out there. They were talking about them. So I cannot comprehend how there's not two sets of photos. If there is even two sets of photos. I cannot, it does not add up to me. There is definitely these, it may not be these particular photos, or maybe these are the photos that have been around since the end of last year. And whatever Mitch Westerman took and whatever happened there is a completely different set of whatever. These side-by-sides that they keep referring to, the side-by-sides. There's something to it. Caitlin, didn't you just join? Maybe I'm going crazy. Maybe I scrolled up. It doesn't equate. The math ain't mathin'. Tell me how these photos just got put out there, and yet there was photos of the girls at the crime scene out there, at least from what I can see right now, in December. Maybe not the exact same photos. The confidentiality is an illusion. Could not say that better myself. It's an illusion. And for whatever reason, we're now just thinking that this is the first time that these photos have come out. It's not. It might be these specific photos, but maybe that's where the F tree came from. Shit, I don't know, but people were talking about the F tree for a long time. So I'm thinking those were actually part of the other part too. I don't think any of this shit's new. I don't think this leak is new. So why is Westerman saying that he took these photos? And I would love to be able to know. I would love to be able to know what photos he actually took. Oh, he had the F tree in 2017. That doesn't surprise me. Well, I'm going back and I'm watching all these old streams where people are talking about it, and they're talking about it like it's not like necessarily real. So I'm thinking that a lot of people didn't like really catch on because it's like all in like conjecture and like, oh, you know, I'm hearing that people have the photos. Oh, this podcaster was contacted asking if they want the photos, but that means that they had them, that somebody had them. Jay Kalkiner posted photos the day they were discovered. He was subsequently fired from his job at the newspaper. Yes, but nobody can ever tell me what was actually in that photo, because what I remember of it, and I don't remember the photo itself, but what I remember of that story is that he posted it and you could see the crime scene in the background. Well, that would not be the pictures that are floating around now. So did Chris Todd send the mass email? That's a great question, ATS. Did he? Don't know. I am too, Jen. I am too. And if that's why I'm like, what photos were actually taken that they saw? You know, Mitch Westerman's probable cause or his arrest. It talks about that the photos were on the table side by side, that he took pictures of the side by sides. There's nothing in there that talks about the date that he took them. There's nothing in there that talks about the date that he forwarded them to anybody. And there only says that he gave them to Robert Fortson. They say that Robert Fortson then gave them to Mark Cohen, and that's the only person they say that Robert gave them to was Mark Cohen. And then Mark Cohen distributed them out to the internet. It's still the only date that keeps popping up is this agreed upon date, because those are the photos that were on the table for the depositions in August. But Mitch Westerman never said he took the photos in August. So is there something else going on that he took these photos a long time ago and that's how they got out? There's something wrong, and I just cannot, I'm not buying what they're trying to sell me. We're dealing with multiple leaks from multiple sources over the years, and it's all being blamed on BNR. Yes, that's where I'm at with it. And then somebody along the lines, whoever sent them to Rick Snape, puts this cursor on there to purposely show something. So this whole leak, really a group of guys trying to one-up each other on Reddit. I mean, yeah, you can break it down. I think it's like I have info you don't have. Hey, Julie, she's doing pretty well. She's on her way to recovery. You don't ever shut up, Rumble Rome. You don't have to. I think that also, I think there's something to the fact that somehow Rick Snay gets the photos and talks about that he has the photos, and then shit hits the fan. Like, because he's not saying he's the only one who has the photos. He insinuates that other people do have them, and that he wasn't the only one to get them. And I think people were like, crap, if anybody finds out we have these photos, we're screwed. So we need to do the right thing and be the good guys and turn it into the police. That's possible, but I think that, I don't know, I think that at least one of those characters has to be on the outskirts and stuff being sent to them, right? I mean, they can't all be getting the info, right? Yeah, he ratted out the murder sheet as having them, LO, before they got to put out their podcast. Yeah, he did. Hi, Heather. I don't know. That guy just seems different to me. I don't know what it is about him. He just kind of rubs me in an odd way. And I don't know if it's because he's trying to keep so hush-hush about certain things that he comes off like shady. I don't know. There's something that rubs me wrong about him. But I do think it's important to know exactly where any of that information actually came from. If these photos have been out there, and they've been out there since there was even a defense team, or since before a defense team could even have them, then they didn't come from the defense team. And this whole gross negligence shit doesn't make sense. Now, if is there two sets, and you have Mr. Mitchie who went in there and took these photos for some nefarious reason? Yeah, shit. I mean, I don't know. I do think it's definitely a lot of like wanting the inside information, which I get. I just don't. I get wanting inside information. I get wanting to have, to understand this crime and to just want it done at this point. And even last year, the year before, so many years had gone by. I get that. I guess what I don't understand is getting to the point where you're interfering and becoming literally part of an investigation. Why? And that's where, I mean, did you not see that coming? Were you blind? I mean, like, how did you not know you were going to end up being a part of this once you're starting to get evidence that you shouldn't actually have? Well, yeah. It's annoying that people don't press MS more about why they didn't go law enforcement when they got them. They waited. Court TV just asked, "Hey, Inky, what you thinking about all that?" I'm surprised they've even had them back on, but that's my personal opinion. But it was a while. They didn't have them on for a while. Yeah, it is a competition. I know more than you do. Ha, 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 ha. Somebody sold them to somebody. There's definitely some money exchange there. Yeah, that was the Baker kid. You're right. He did. He talked about another person that was taking photos out there. I do have the photos digital that don't have the watermarks on them. And I do think that those were actually taken by the searchers. And maybe those were sent out by the searchers. I don't know. I don't know that to be true or not. And then we also have to consider then if it's possible that a searcher would have been somebody that would have taken photos of the victims and then put them out and gave those to Chris Todd. I don't know that to be true or not true because we just don't know. But does that mean that those photos have been circulating for a while? There's probably a lot of photos out there. I was surprised they hadn't had him on for a while, and then Four Pitbulls isn't here, but he comes in and makes a comment like, "Where the heck's Murder Sheep been?" And then I go to watch Court TV, and I'm like, "Seriously? You just literally you brought him out of the woodwork." They're still doing their podcast though. They are. Hey, Humanimal. Chris Todd is he's an agitator. Yeah, and I think that, I mean, every good story has to have the antagonist and the protagonist, right? I mean, that's kind of part of it. That's how people get answers. And, they go in, they stir shit up, and they find things. Those people aren't normally the people that you want to call a friend because you don't know what they're going to do to turn it around on you. The problem I have with the searchers taking the photos of girls is because the majority of people that we know were in the search groups that found them were family. And so to me, it's almost like hard to imagine that you come across that scene and you're not just like, holy shit, falling apart, shocked, and like that any type of your brain is going, get the camera. I don't know. Diabolical. Yeah, it would not surprise me. That's why I said there's just something that gives me I don't know. I don't know. I don't like it. That's why I said I can't tell if it's just because he's trying to hide things, and so he comes off really secret-y. Okay, so let's get back to this real quick. So respondent had an absolute duty to refrain from severing the attorney-client relationship. Not a single Indiana case has tolerated similar behavior from a trial judge. There are only two narrow situations in Indiana where a trial court has jurisdiction to sever the attorney-client relationship against the client's wishes. One, the lawyer is not a member of the state bar. We talked about this. Two, the lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on anything other than these two reasons. Sorry, I had to sneeze. And throughout their 8,000 words and nearly 50 pages of briefing, the responding parties failed to present a single Indiana case tolerating this behavior from a trial judge. Every Indiana disqualification case cited by the responding parties involves one of the following. One, a conflict of interest. Two, an unlicensed attorney. Or three, a judge being reversed because she removed a lawyer from a case for some other reason. This one's conflict of interest. This one's conflict of interest. This case, Barham versus State, the judge reversed for rejecting lawyers' conflict-free representation. And that one's from conflict of interest. Attorneys Rosie and Baldwin were licensed attorneys without any conflict of interest. The judge had an absolute duty to refrain from severing the attorney-client relationship. Respondent obstructed the attorney-client relationship for reasons totally unconnected to the Sixth Amendment. When respondent severed the attorney-client relationship, she was acting on subjective opinions about the defense's conduct outside the courtroom, not on any Sixth Amendment concerns that might alter the trial's outcome. The respondent argues that attorneys Baldwin and Rosie committed multiple violations of the rules of professional conduct and that she acted to, quote-unquote, protect relators' Sixth Amendment right to effective assistance of counsel. The rules of professional conduct are not coextensive with the Sixth Amendment guarantee of assistance of counsel. Ethical standards can apply to a broad range of attorney conduct totally unconnected to the Sixth Amendment. And the Sixth Amendment is concerned with deficient performance that has a reasonably probability to alter the trial's outcome. And this is all the cases that they're citing. Attorneys Baldwin and Rosie did not violate any ethical rules. And the judge, if she believed there was a violation of rules of professional conduct, should have reported the violation in accordance with her obligation under Rule of Judicial Conduct 2.15. But this never occurred, despite respondent claiming there was a violation of the ethical rules nearly a year ago, when counsel issued a press release in November of 2022 affirming Richard Allen's innocence. In any event, respondents' subjective concerns with attorneys Rosie and Baldwin are wholly unrelated to the Sixth Amendment. Respondent's primary ground for her subjective belief about counsel's performance was the evidence leak discovered in October. Yet attorney Baldwin was a victim of a crime allegedly committed by Mitch Westerman, who surreptitiously took photographs of evidence. Law enforcement, a prosecutor, and the Johnson Superior Court have reviewed this matter and found probable cause to believe attorney Baldwin was a victim of a crime. That's true. I mean, they charged him. Give me 1 second, you guys. Sorry. All right, let me see what you guys are saying in here. If these photos was out 2 years ago, the people should have seen them, and that would prove how these creators built their channels on photos that no one should have had. Well, I'm telling you, they're saying they have them, and they're saying that they're being offered them. And it was not in October of this year. I've done photo work as fed up as this before as a performance artist, so it's easy to replicate. We're still reading through it. One of them appears in chat. It's just a photo. The news media always produces photos. Yeah, it's true. Part of what the Murder Sheets, the number 14 fake true crime podcast in the Midwest, is a passionate love story between. Sometimes I should probably read these before I highlight them. The clothing in the water has been out since at least fall of 2021. 2021. Yeah, I think that's what I have written down, Chris. I think so. I think that's what I put, right? Was it fall of 2021 or 2022? I think ISP is a much larger machine than small-town Delphi goof troop. Any ISP investigator would be so pumped to find money trailed for the leak, it would make their career. But they're not even, I don't think they're even going to look into it, because I think that that's going to come back on them. Even if this leak is separate, it's just going to open a whole can of worms. Nope, they do not. And this is what I tried to say, and people get really upset because there's a lot of emotion. There's a lot of emotion behind it because of what the photographs consist of. But the truth of the matter is they're just photographs. And if they really were going to harm anybody's ability to have a fair trial, then it would be more at a federal level that this would be stopped. And I'm telling you, there are states. Florida has the Sunshine Law. I got so many crime scene photos from Florida cases. I have so many crime scene photos from Florida cases before trials ever even happened, because they feel like it's not going to do anything to harm the trial, so they let him go. He then transferred. Hold on, Alec. Oh, I think I missed another comment from you up here. Richard Allen is the photographer. What? All right, Alec. I'm going with you here. Let's see where you go. He then transferred the phone to Klein, who went to Vegas and sold it for huge money. The Odin aspect is BS. The photos sure as hell did meet the public, just not like this public, right? A different set of public, an unscrupulous set of public. That was the big thing I always thought about the Kleins too, is that weird Vegas trip. Well, I'm trying to following Alley Cat down here. Hold on. I'll go back to your guys' stuff. You have to look at the timeline and evidence. It is there. It all fits a heck of a lot more than Odinist, for fuck's sake. The only thing that I will throw off, and I don't even necessarily mean Odinist, and so, but I think just because of all the stuff that we know of now with that memorandum, is whatever was on the girls and whatever's on the tree was intentionally done for a reason to resemble or mean something to the person that put them there. What the hell that is, I don't know, but I definitely think it has something to do with it. And shit, you're welcome to feel that's a. I mean, it's a possible theory. It's definitely something that's a possible theory to pay attention to until you can get rid of that. You know, until you can prove yourself either right or wrong. That's how I feel about it. That's what theories are. Can this be a never-ending tennis match of responses? Is there a limit? This is it. So they'll either allow her to submit this response, which I believe they will, and then it's done. So if you think of it like when you're in trial and the prosecutor puts a witness on the stand and they question them, right? And then the defense gets to question them, and then the prosecutor gets to re-question them. So they kind of get the last word because it's their witness. So if you correlate that to what we're doing here, it's like the relator, which is Cara on the side of Richard Allen, is more the prosecution side, and Judge Gull is more on the defense side. So that's why I believe they will allow her to submit this response, and not to mention she has some good points. She has additional evidence that supports her needing a response, because they got to put, you know, they put all this stuff into motion and then they responded. Meaning Judge Gull. And then So does it outweigh? So I think they'll let her respond, and then this will be it. Then the Supreme Court has it in their hands, and they make the decision. So like the first writ, it's done. There's nothing else that should be happening with the first writ. All things should have already been filed and done. The Supreme Court gave a deadline. Everything was submitted by the deadline. And because the respondents are waiting till the last minute, then you have Cara who comes in on the back end and says, hey, please let me have the last word here because I now have more to say because of what they said. So this is it. This would be it. It'd be done, and then she has to decide. Right. That's a fair point. It is a very fair point that everything that was put in that memorandum, I shouldn't say everything because that's very broad, because I do think there's some things that they handpick, just like the other side. Both sides will handpick certain pieces, and I go over that all the time because it fits into what they needed to fit into. But the fact that there was an entire team that was focused on investigating this completely different angle, and then it just nobody ever did anything with it. There was never an end. There was never a resolution. So that's when I say, like, you have a theory and you have to basically essentially prove yourself right or prove yourself wrong, right? And if you prove yourself wrong, you got to come up with a new theory. Well, they never did anything to prove themselves wrong. There was nothing that ever stopped them. We don't even know all the stuff they had over there because we don't actually have access to the evidence that was attached to the memorandum. But boy, would I like to. It's not about the killer being honest or being an actual ritual. It's about other suspects and loose ends. Right, and I think it kind of gets washed over because of the Odinism angle, but I don't even know if it's necessary that it was. I really go with what Click said. I don't know. There's something about Click and Murphy and even Ferenczi, but Honest Murphy and Click, I just click with them. I really do, because I feel like he's like, hey, wait a minute. I have more evidence against these guys that I collected in my years of digging into this than you guys put in your probable cause affidavit. So please just explain to me why you guys have the right guy and I don't. And then they couldn't. And that is like, what? Why couldn't they? They should have easily been able to say, well, hey, buddy, we have the girl's blood in his car. We have his DNA on their clothes. We have these bullets. We have all of this stuff, not this mere presence, the guy was there kind of scenario. Because if we're going to go with the guy was there at the time it happened, you really have a bunch of other suspects to look at. And you're not going to find motive, but you're not finding motive with Richard Allen either. And that was one of the reasons that a lot of the other people who were there got kind of pushed out of the way, was because they didn't have motive, right? Why would they have done it? Well, why the hell would Richard Allen have done it? I know. That's why I talk to you about it all the time. Remember, Mark sent me that mass email. The mass mail has something to do with an old convo. Yeah, I know. We're going to get to the bottom of it. Hi, Anna. People keep saying that. Oh, I already read that one. Sorry. Of course. Yeah, I absolutely will listen. It's not something that's provable, but it's not something that's, you can't prove a negative. So nobody can say that's not what happened because we don't know that. We don't have all that info. Until we have more info, it sits on the list of possibilities. Never came to fruition. Nope. How do you piss off a judge? Try to win the case by defending an accused man with every tool available to you, many of those tools forged by the prosecutor. Yeah, they don't like that. Hey, Ground Up Garage, what's up? He did? Oh, I missed that. Nope, never explained. Never explained. We still don't really have an idea of why. And then there's like these weird connections with his family members and the people that are in Rushville. And I haven't got to the bottom of all that yet either, because that's also very strange that there's these weird connections out there. See, and that's another good point, Melissa, because these are actually separate things. You have like the Vinlanders are in like the MC. And I don't think that's necessarily what we're talking about. I think what they're talking about is this merry band of misfits that wanted to be part of this group and tried to do something to make it happen. And they get all convoluted, and then I think that's when it becomes like, oh yeah, nobody can really, that's got to be a joke. It's bullshit. It's none of this. It's none of that. But it's like there's something to all of it, because I really do believe that there was a team of investigators that have supporting evidence that they couldn't let it go. Hey, Kayla, evidence backs up the defense. The LE prosecution literally lied. They changed their witness and other evidence to suit their oh so convenient PCA. And that's one thing, is we can't actually determine whether Baldwin and Rosie lied. There's nothing in there that you can say they put that in that memorandum and it's a lie. We don't have that. Now, is it possible? Yeah. Is there some exaggerations with certain things? Is there some, obviously a shit ton of typos, we know that, but I mean, and like the weird stuff about the dexterity of one man that was just really over pushed. But there's nothing in there that I think anybody, whether you think guilty, innocent, no matter where you're at on that scale, can anybody show where they lied? Because I do think the ones that are looking at the PCA, and we just went over it again yesterday. We went over the PCA, the search warrant. I mean, there's points in there that are provable lies. That's an issue. So is there a provable lie on the other side? Do the math. I mean, math. Follow the money. Got to read up on Crystal. I go back up to crystals. Let me see. I missed it. I do think that trip to Vegas was quite convenient. Keegan Kline said he went there to buy weed for his friend in Delphi. A lot of it. But the deal fell through. Well, of course it did. There was no deal. So he never got the money. I keep my mind open and allow room for theories. I wouldn't be surprised if we hear about a connection to KK or Kokomo Crew or Fouts or Ellis. Well, we know that there has to be some form of connection, because they obviously had conversations with him about the girls. So we know it was as simple as, wait a minute, you were over here catfishing and you were talking to Libby. Now, if that's all it was, why do they take him to the Air Force Base? And people are like, well, you know, federal, there's the whole thing when it comes to, you know, if you take them to the Air Force Base, then you can talk about like the federal crimes and so on and so forth. Okay, so then how does that tie into Libby and Abby? Because it's on the thumbnail, the thumbnail drive map that has to do with Richard Allen's case. So something about Kline fits in somewhere. I just don't know exactly where. Hi, Dark Horse Justice. Hey, Sharon. Hey, Starlight Ann. Acid-true Odinism is more common than one would think in Indiana. See, I get behind, and then like Nancy says, yes, T, and I'm like, I don't know what I said, but I'm going to, yes, go for it. Yeah. Vinlander. Did I say it wrong, or did you spell it wrong before? I think we know, we got you. Okay, so maybe someone did their research on runes so they could make the crime look like the Vinlanders did it. It's not, I mean, okay, so then do you have, if you're trying to stage it to look like somebody else did the crime, and you pick a specific group of people, then you probably know something about that group or have a bad interaction with them, or there's something there. You know what I mean? Like, why you're just like, you know what, I'm going to search some Norse pagan religions and just see what I come up with, and then I'll just kind of set the scene up to look like that. That's weird to me. Normally, if you're like, I'm going to, I hate so-and-so, and I'm going to make it look like they did something. Yeah, I want to hear Liggett and Tobe's depositions for myself, and we'll see if they lied. Defense attorneys say cops lie every day. I'll say neither Liggett or Tobe are Columbo. Agreed. There's so many of these pieces that I think that we have to hear before we can make an assumption. And I promise you, hold on, art of deduction. Let me finish this, and then we can chat. I promise you, though, that when all of this does come out, we're still going to have people who don't agree and hear and feel differently about the information. It's just how it's going to go. Wow, they all know each other. William Duff arrested for dealing in possession of meth and marijuana. Yeah. They're all connected. That's why I said, even I get like there's a lot of connections in a town of like 3,000 people, but they're all connected. It's just so weird. It's like the 6 degrees of Kevin Bacon over there. There's just something about the state trooper. I don't believe he has a clue, but puts on a front, which is making him appear foolish. Yeah, freaking Indiana. Runes are actually an ancient alphabet and not unique to Odin or Vinlander. Wonder if Masons use any of that alphabet. Yeah, from my understanding, there's probably a lot of groups that use it. And then they all have a little bit of a different interpretation to what they do. It's like the English language, right? People in England speak English, and people in America speak English. But they don't actually speak the same English. Yep. That's why I'm like, there's still something to it. I just don't know exactly what it is. Okay, so let's finish this up. Where was I at? Yeah, they're the MC. The Vinlanders is the MC. Then if you look at like the Odinists, that's considered more of like the gang in like prison, in the prison system. But then you have people who practice Odinism. All right, where were we? Oh, because they put the press release out in November of 2022 affirming Richard Allen's innocence, which we read through, and then we went through and read through the code, and it literally looks like everything that they said in that statement would be allowed under the 3.6 rule. In any event, respondents' subjective concerns with attorneys Rosie and Baldwin are wholly unrelated to the Sixth Amendment. Respondent's primary ground for her subjective belief about counsel's performance was the evidence. Oh, we just read through this too, didn't we? Yeah, because he was the victim of a crime. We read that. Okay, so what happened to Attorney Baldwin in October and the other instances cited by respondent in no way affected the quality of representation attorneys Baldwin and Rosie provided Rick and did not disrupt their trial strategy. I concur. Rick clearly and repeatedly asked respondent to refrain from severing the attorney-client relationship, but she acted anyway. Disqualification was first mentioned by the state in a telephone conference on October 10th of 2023. The very next day, Rick unequivocally affirmed in writing he still wanted attorneys Baldwin and Rosie to represent him. The trial counsel filed Rick's letter with the court and included a lengthy letter to the court that explained that the court lacked jurisdiction to disqualify counsel because there was no conflict of interest. That same day, the trial court ordered counsel to cease working on Rick's case. Before the hearing on October 19, 2023, Attorney Baldwin retained counsel and filed a memorandum, again, informing the trial court that it lacked jurisdiction to remove counsel absent a conflict of interest. During an in-chambers proceeding held before the hearing in open court, when respondent revealed that on her own motion, she was disqualifying counsel. Attorney Rosie argued that respondent lacked the authority to do so. After the in-chambers proceeding, Attorney Rosie filed a notice informing the court that he was remaining on the case as Rick's attorney, as well as a motion for respondent's recusal. The court struck the pleadings and indicated it would take no action on them. And this was what I thought was, in her response, she says, and the Attorney General also says, that she did nothing with them. That she put them there and she just did nothing because they weren't attorneys of record. And that's not true. She actually created a court order for the clerk to remove them. That's not doing nothing. That's doing something. She absolutely did something with them. Attorney Baldwin, by his counsel, filed a motion to reconsider his removal as counsel, arguing that respondent lacked jurisdiction to disqualify counsel, particularly considering that a motion for her recusal was pending. Respondent did not take any action on the motion. The day before the next scheduled hearing in Rick's case, attorneys Baldwin and Rosie entered their appearance on Rick's behalf as private counsel. At the hearing, Rick's attorneys argued again that the court had no authority to remove them as counsel. On each of the 6 occasions mentioned above, attorneys Baldwin and Rosie informed the court that respondent lacked jurisdiction to disqualify them. The claim was clearly and repeatedly presented to the trial court, but the trial court chose to act contrary to her absolute duty to refrain from severing the attorney-client relationship. The respondent delayed the efficient administration of justice. Respondent's conduct in this case was particularly harmful because severing the attorney-client relationship delayed the efficient administration of justice. The Attorney General argues that the need for efficient administration of justice should be balanced against a defendant's Sixth Amendment rights. Indeed, Indiana courts do not require judges to unflinchingly grant continuances or delay proceedings so a defendant can bring in counsel of his choice on the eve of trial. Trial court balancing the defendant's rights to the trial in a timely manner with defendant's desire to delay proceedings indefinitely while he waited for his preferred counsel to recover from a potentially fatal medical condition. A defendant's last-second gamesmanship for a new lawyer causes substantial loss of time for jurors, lawyers, and the court. But the opposite situation is actually what occurred here. Respondent delayed proceedings to insert counsel of her choice. When the judge severed the attorney-client relationship in October, trial was scheduled to begin in January. Rosie and Baldwin spent nearly a year reviewing the voluminous discovery, conducting depositions, developing a speedy trial strategy, and pursuing a defense of third-party guilt. Attorneys Baldwin and Rosie were active members of and in good standing with the Indiana Bar, and they told the judge they were ready to try this case in January. There is nothing in the record suggesting otherwise. So here's something that's just a tad ironic. A tad ironic. Remember, they say that, we told them on October 2nd we wanted the deadline for discovery, and then by October 4th, she thought that we were going to be asking for a continuance, and we said, no, we're ready to go to trial. We're ready to go to trial in January. And that was October 4th, and then all of a sudden all this leak bullshit happens, right? But in her response, or the Attorney General's response, I don't know if it was in both or just one, but they said that wasn't on the record, that can't be filed, and it wasn't on the record. But remember, her telling them that she was considering disqualifying them, that's okay. But them telling her on this phone call, hey, we're ready to go to trial in January. Nope, sorry, not on the record. Too informal, doesn't count. Nice try, though. The judge, on the other hand, had not ruled on several of Rick's substantive motions. The Franks memo, which sought to suppress the warrant search that uncovered a firearm, has been pending since September 18th, 2023. As of October 31st, 2023, respondent had not finished reading the motion. Just, I haven't finished even reading it. For the motion for the state to produce Rule 404 and 405 evidence, which would inform counsel's decision whether to put Rick on the stand, had been pending for nearly a year. Also pending is an August 8th, 2023 request for transcript of the June 15th hearing, which counsel needed for use at a deposition and a hearing. Finally, a motion in limine on ballistics evidence has been pending since June 13th, 2023. The motion seeks to exclude purported expert testimony that an unspent cartridge found near the crime scene had been cycled through a gun found in Rick's home. A ruling from this motion is obviously critical to the efficient administration of justice. When respondent severed the attorney-client relationship, she was not balancing the Sixth Amendment right against the efficient administration of justice. On the contrary, she violated the Sixth Amendment when she inserted counsel of her choice and delayed all proceedings, denying Rick, the victims, the witnesses, and the public the efficient administration of justice. Let me see what you guys got going on in here. Yes, so I think the scariest part of conspiracy theories is the fact that a lot of them are real, right? Whether RA or not, organized killers usually have 3 crime scenes: abduction, murder, disposal. I theorize that's what happened. I find it, the only thing I find hard to believe about that they were taken and brought back, and this is just my personal opinion because I honestly have no fucking idea. My personal opinion is that they would take them back so close to where they were taken from. Like, why not take them somewhere else and put them there? Like, it is, I mean, you're absolutely right on the fact that there is typically 3: abduction, murder, disposal. But we're almost like abduction and disposal are almost at the exact same point here. So then that makes me go, okay, is it abduction, murder, disposal all within this vicinity? Right. Valerie Tyndale was found in Rush County where Rushville is, so my mind goes straight to Elvis Fields. I wonder if Patrick Scott knew him. Yeah, was Patrick Scott connected to any of these people? It's a great question, but I mean, we do know that there's just bad people out there in the world that do bad things, sadly. I want to be Carol when I grow up. I know. She's pretty badass. Yeah? Well, I mean, I guess we could go literal, because then you're right, because you got abduct them at the bridge, kills them by the quote-unquote F tree, and then moves them to the disposal site. And it all just happens to be within that time frame. Right. Oh, bye, Alley Cat. Thank you for being here. I appreciate it. You can go watch some Fargo. No, that the first 50 pages is all about Masons and their beliefs. Nancy, did you make a comment before that I missed? Y'all wouldn't believe who the maker of this Masonic Bible is. You just can't make this shit up. It's Holman. At the end of the day, the establishment doesn't like regular people. They actually hate regular people. It's all about power and control. It's unfortunate, but I'm not inclined to disagree with you. Oh, night, Rexy. Oh, Angela, anytime, of course. I appreciate you guys being here. Okay, so let's go through. The remedy on appeal is non-existent. Only an original action can achieve a speedy trial with attorneys Rosie and Baldwin at the helm. Rick is a pretrial detainee who is over 50 years old, has deteriorating health, and is housed in prison among individuals who've been convicted of crimes. He files this writ asking for attorneys Rosie and Baldwin to be reinstated, to remove the trial judge, and to mandate a trial within Criminal Rule 4B1's time frame. Only this court can deliver that relief. The responding parties failed to address the interwoven connection between Rick's speedy trial request and the respondent's Sixth Amendment violation. Here, murder charges were filed on October 28, 2022, and the parties agreed to set this case for trial on January 8th of 2024. which was outside the criminal Rule 4C period. Rick had a right to assume trial would be held on that date. Rosie and Baldwin spent nearly a year reviewing the voluminous discovery, conducting depositions, developing a speedy trial strategy, and pursuing a defense of third-party guilt so they would be ready for trial on January 8th. Attorneys Baldwin and Rosie were ready to try this case as scheduled. Respondents severed the attorney-client relationship over Rick's objection and thrust new attorneys upon him who were unprepared for a 3-week trial, scheduled to commence in 3 months on January 8th. No attorney coming into this case could be ready for trial of this complexity within that time frame. Only attorneys who have worked on this case for a year could be prepared. In short, only attorneys Baldwin and Rosie can be ready for trial within the limits of Criminal Rule 4. A direct appeal after a jury trial is wholly inadequate. Trial has already been continued at the request of the new public defenders by 10 months to October of 2024, and the trial may very well be continued again. When trial eventually proceeds, there will be an unresolved Sixth Amendment issue. Carroll County, Allen County, the witnesses, the victims' families, lawyers, and Rick will all be dragged through a constitutionally infirm trial. The Sixth Amendment issue will permeate every aspect of this case, rendering a fair trial impossible and a tremendous waste of resources. Trial will be for practice only. Furthermore, the remedy on appeal will be retrial. Not retrial with attorneys Baldwin and Rosie. Richard Allen wants a trial with attorneys Baldwin and Rosie, and only this court can grant that relief. Even if Richard Allen is acquitted at trial in October of 2024 or months thereafter, his rights will still be violated because justice will have been long delayed while his 50-year-old health continues to deteriorate in prison. Justice too long delayed is justice denied. Martin Luther King. An interlocutory appeal would only exacerbate the harm Rick has already suffered. Even under the best of circumstances, an interlocutory appeal takes months before a decision is reached. Assuming one can receive permission from both the trial court and the Court of Appeals, we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. Now, given respondents' comments regarding trial counsel's performance and credibility, she cannot oversee a trial where they represent Rick. A judge shall be disqualified in any proceedings in which their impartiality might reasonably be questioned. And if they are put back on the case, absolutely, I think her impartiality would be questioned. But that's me. Respondent argues that neither Rick nor attorneys Baldwin and Rosie demonstrated that respondent had any bias or prejudice toward them. Yet even before the circumstances surrounding the discovery leak had been fully investigated, respondent indicated that she was leaning towards disqualifying counsel. And that's true, because if that conversation happened on October 10th and she just found out about the leaks on October 6th, nobody even really knew exactly what was going on. And then what he puts in, Baldwin puts in that he, or was it Rosie? One of them, I don't remember, puts in about Mitch Westerman, and she immediately goes to disqualification over it. That's interesting. Respondent also claimed counsel's motion for an immediate transfer of custody for Rick had a lot of inaccuracies when compared to the state's affidavits. Respondent indicated she was denying the motion even though no hearing on the motion had taken place and Rick had been given no opportunity to present evidence. Yeah, she denied that in chambers before they were even let go. Respondents, and this is why I knew immediately when that came out that she was doing any type of rulings before she even read them that letter. She never had any intention of going into that courtroom. She never had any intention of walking out into that courtroom. That's why she ruled on the motions before she told them about her pre-written stuff, because she knew she wasn't walking out there, not with them anyway. Respondent said the same thing about Rick's motion requesting a modification of the safekeeping order filed back in April 2023, that it contained inaccuracies and falsehoods. Respondent based that on the state's evidence presented at a hearing on the motion, but failed to acknowledge that respondent relieved the sheriff of his burden to transport Rick's primary witness to the hearing so that he could testify in support of Rick's motion. Respondent based that on the state's evidence presented at a hearing on the motion, but failed to acknowledge that respondent, judge, that she herself is the one who relieved the sheriff of his burden to transport Rick's primary witness to the hearing so that he could testify in support of Rick's motion. And she's the one who actually denied it. Major Lesenby was advised by the court to disregard any further efforts to retrieve inmate Baston from the Westville facility. Shit. This court is the only court now that can ensure Rick receives his fundamental right to counsel. A writ of mandamus is appropriate to reinstate attorneys Baldwin and Rosie as court-appointed counsel, to set a trial date within 70 days from the issuance of the writ, and to remove the special judge and appoint a new one. And the Rockaways, here you go. It is fewer than 4,200 words, as cited by rule whatever it was, and the foregoing electronic filed. Okay, so this is her response, but remember, this is not approved yet. So it's there, it's ready. It will most likely be approved to be put in, but it's not necessarily approved yet. So I would assume probably tomorrow. What is today? Thursday. I would assume we'll probably get an order tomorrow by the Supreme Court that says, yeah, we will allow it. Confirmed, Rockaways, confirmed. God, Cara is she's a little badass. Now I know that she said when she was on with Bob Mata, she said that she does these, but it doesn't typically work out where the judge is going to be removed and the attorneys are going to be put back on. Like that's not. She's not in the that's probably going to happen, but she knows that she's putting up the good fight, and what she's doing is she's setting everything up, and everything is going to be, everything is part of this case now, and that's what it needs to be. So even if it gets denied, it's the purpose is to make sure that it is all still, it's all put out there in print and everybody knows what's happening. She is a badass. She really is. Okay. So what do you guys think? Everybody going to bed? Who's going to bed? Okay, night. Coach Kev, you going to bed? Who else is going to bed? Somebody else said goodbye, I think, and I missed it. If you guys went to bed, good night. Go to bed. I'm not going to bed yet. It's still pretty early here. My brain tries to make connections where no connections are yet. It's just some true crime mind. Yeah. I can tell you that every case that I look, when I start looking like through people who are connected to each other, I find the exact same last names as other cases I've looked at, and it drives me bonkers. I'm like, why do you have the same names from that case? Look into the arson fire at Judge Jason Thompson's house in 2022. His wife and child died in a fire. His wife was a state trooper that worked on the Florida arson case and the Delphi case. That's Stephanie Thompson. She's the one that was she did the lie detectors. Yeah. I would think it could be reasonably be questioned. What's up, tiny human? What do you need from me? Hey, Chloe's mom. I'm fangirling. I fangirl over Cara. Yeah. No worries. It's 8 a.m. That's just crazy. Bob's live at 8. Is that Eastern? Rather be... Yeah, that's true. It's true. She has bigger balls than most men. I don't know. I'd say ask Voorhees, the hacker, but you're the psychic. Maybe you can tell us. Is he really like a hacker though? I don't know. Yep, she's creating her record and she's doing a great job at it. I would not trust this judge to save my life. Yeah, don't get in trouble where she's at. Well, he's live in 35. Okay, got you. BH is a Mason, and so are the cops. And so is Nick McClelland. They're all Masons. But I struggle with the whole the Mason thing because I know that there's offshoots to everything. My grandpa was a Mason, and that guy didn't help me get out of a damn traffic ticket. So I'm like, hey, you got no pull. Okay, give me 1 second. Let me send this over. Let me see what this is. Oh, that's best on. Okay. I just pulled up what you sent me, Frank. Okay. Minor death rates by fire in Carroll County are several 100% higher than the national average. It's crazy the amount of fire that's over there. He's not a real Freemason. He can't even pee straight, let alone. Yeah, if you're indigent, you're really screwed. Was it Dwayne Kessinger was a Mason? That was always a big deal in the Watts case. Shane Evans has an uncle that was Cass County deputy that was sent to prison for 152 years for being a pedo, and the judge that sentenced him was found crushed under the car. And that's what why can I think? That's what the video was about yesterday. And I want to say unsolved crimes uncovered, because I always want to say uncovered crimes, unsolved crimes uncovered. That's what she did a video on yesterday. She was getting all kinds of shit from somebody who knew the judge too. I was like, they didn't even watch the video. They just saw that there was something about the judge and got all mad, but whatever. We all get those. It was a really good video. Yeah, and so he passed away. But then you also have like the weird connection because Brad Rosie's, is it his uncle or his? I'm gonna have to pull up my family tree. It's his uncle or his. Let me see. The guy who put him in prison is actually related to Rosie. Let me see if I can find it real quick. I know I wrote it down too. Let me see if I have it in my notes. And then Frank's going to come up. What's up, Frank?
Oh, there we go. Hey,
there you are. Hey. So,
how you doing?
How you doing? Are you supposed to be like in bed yet? Isn't it like middle of the night your time?
Yeah. It's like, let me see, 1:30 almost.
So, what's up with the marshal?
Well, it depends if you want to pull up the index real quick.
Yeah, hold on.
I don't want to demand you to anything though.
No, you're good. I know that I think it was actually, wasn't it Bree's interview that was done at the marshal's office?
Yeah. And that's the only one that stands out. That's really interesting.
I was weird because I remember I was like, why the heck was that done at the marshal's office? I thought that was quite interesting.
I love that you have like entire maps in order to. I can't. My brain can't.
I've been working on this damn thing I work on it a little bit every day because there's so much to this case, and I've got to be able to put all my stuff in different places and like actually like know where things are. So I created this whole thing, and it literally looks like rabbit holes if it'll load, which it doesn't want to.
Is it like a mind map?
Kind of. Yeah, so you go through it and hold on.
It's pretty cool. Yeah, I tried that once and I was like, nah. I'm like really
No,
chaotic,
it's
but
super
I know
helpful.
like my stuff.
It's helpful because there's so many different people, and then somebody will throw in like a different person. And then I'm like, who the hell's that person? So, okay, hold on. So let me go to the leaks. And then it's the thumb drive map. Yeah, and then it just goes in. Then I put all this in here so then it's all ready to go. And then you can just click on them and then go through it. Makes it easier. So I think it's in here. So I think it was Breeze. Breeze was done on 8/27/2020 at the marshal's office.
Mm-hmm. Now, that one is specifically really interesting because Bree obviously is also a witness in one of the sketches. Um, Now, if you would use just Google or a Chat GBT just to get a kind of a picture, why the U.S. Marshals would be involved in any sense, then it becomes really interesting because they
Okay,
can
so
do.
like, what should I Google then? Like, why would U.S. Marshals interview
Or
witness?
be involved in like homicides or whatever is kind of like a general thing. Then a kind of a cluster would
Be
come.
involved in a homicide case. Every law enforcement has a specialty, and the specialty is hunting fugitives. Too much on their plates and can't dedicate the time or resources necessary to catching a particular criminal, they turn to the marshals. So the duties of the U.S. Marshal include protecting the federal judiciary, apprehending federal fugitives, managing and selling seized assets acquired by criminals through illegal activities, housing and transporting federal prisoners, and operating the witness security program.
Let me see what I got
So what are
here.
your thoughts there? Okay.
Hold on, because I
Okay.
always ask my assistant ChatGPT.
Okay.
So let me see. Um, so I asked when the U.S. Marshals get involved. Sounds really general, but the United States Marshal Service is a federal law. Yada yada yada. Yeah, fugitive transportation of federal prisoners, witness protection, security for a federal judiciary. Let me see. I was going to say execution. I was like, hold on a second. No, execution of federal court orders and special operations.
I think you might
Now,
need to turn your mic up a little bit.
oh, hold on a second.
I'm kind of loud, Frank, so if people get on here and
Sorry.
they talk all soft, it makes me sound really loud.
Do I need to repeat it?
Probably.
Okay, that's fine. So let me see. You had fugitive transport. So fugitive apprehension is the first one. Transportation for federal prisoners. That's the second one. Witness protection is the third one. The fourth one is security for a federal judiciary. The fifth one is execution of federal court orders, and the sixth one is special operations. Now, interviewing a witness. Why would what things could you eliminate?
That let me go back to it. Let me pull it back up. Hold on. Managing and selling seized assets acquired by criminals through illegal activities. Housing and transporting federal prisoners. So witness security program should be in witness protection. That would be weird. Apprehending a federal fugitive. I don't think she was a federal fugitive, so I think that one would go. So what else you got? Do you think she's a fugitive, or do you think she's going into witness protection?
No, not at all. But then
I'm
we have
joking.
special operations.
Yeah.
Now, if you reflect back on Key and Klein being questions by U.S. Marshals, remember the Wabash River search?
Yes.
What does that tell you?
Was that the same time frame?
Well, no, it was. Let me see, 2020. That's when the Wabash River search happened, and this interview was in. No, 2022 was a Wabash River search. Was it? I'm hella confused.
Yeah, that was 2022. Wasn't it happening like right before? Yeah, it was 2022. I think it was happening like right before he was arrested. Right before Richard Allen was arrested. And people were thinking that there was possibly something that was found there that tied to Richard Allen. But I don't know how that would have to do with
let's say allegedly. But okay, I can agree with that. Now, Artist is saying something interesting. They took Keegan especially out of place or out of jail for that interview.
Mm-hmm. Yep.
Now, if that is all connected, I do not know. But what I get to hear, I feel like freaking Chris Dodd with my sources. I cannot talk about it. So, folks, see you again in 5 episodes. What Gray is saying right now, because Gray has been kind of on the Keegan Klein trail right now, is that these connections are intertwined. Otherwise, Allen, his arrest wouldn't make any sense because of what, let me see, it was not Alex Voorhees, but the girl Voorhees, what was her name again?
Riley.
Riley.
Yeah.
Yeah. And so I was talking with Becky because my source, Ruckus, gives a shit anyways. He was saying that the U.S. Marshals and her being interviewed by the U.S. Marshals is really key for some reason. And he has been going on this Keegan Klein trail for a while now. And I know CSAM projects are really sophisticated and difficult, but it shouldn't be this difficult. My proposition is that, at least. So that was that. No clue why I went on about that, but the reason why I wanted to come on is obviously because of I was listening you back because you were talking about the old leak or the leak.
Yes.
And the thing is that, you know, I had a pretty hefty conversation with Mark. And by the way, I don't talk to him at all, or at least he ignores me, and I totally get that. But the thing is that he was talking about an old conversation he had with somebody that ended up in the mass leak. Now, if you ask me, there can be only one individual that keeps having information, keeps going on a certain TV show, keeps having collaborations with certain individuals that are, in my opinion, kind of suspicious.
Chris Dodd?
Yeah.
Jason Jensen?
Yeah. See, and I talked to Jason Jensen. Sure, he didn't give me a lot of information, but he gave me a lot of information by process of elimination.
Okay.
No, Sloofy, he was talking about a conversation that happened a long time ago.
So Mark was talking about a conversation that took place a long time ago? Just want to make sure I'm on the same page. Okay, so Mark's talking about a conversation that...
Oh, go ahead, sorry.
Was it something that a conversation he had been a part of, or a conversation he knew about?
In essence, they just wanted to let Brandon Woodhouse share the information that he had to get rid of his tort claim.
That Brandon did.
Yeah.
Okay, so he was sent. So he was sent there to try to figure out how to get rid of the tort claim.
No, just by sharing that, he already got loss of his tort claim.
Okay, so what are your thoughts on it? You think that Mark started talking to Brandon Woodhouse with that purpose, or that he just took the information he was able to gather and passed it on, which helped to get rid of the tort claim? Do you think there was intention?
Somewhat, yeah. And we don't know what Brandon actually got. Because the things that I keep hearing is that people have access to the entire discovery, not just those crime scene images, but way more. And it makes sense because Westerman is saying that he only took crime scene photos and some documents, right? But how in the world do I have such specific copies that I released about those sketches that were unreleased, right? Those
Correct.
do not look photographed.
No. Somebody had those before. And that's
Yeah,
what I was saying, is there
100%.
are creators that were talking about that they had or had access to the crime scene photos back in December of 2022 and January of 2023.
Mhm. I mean, we have to keep in mind that this case has been going on forever, right?
Right.
And I truly believe that that leak went on way longer, and that has been the one that has been exposed now, and the defense is being, well, caught for the blame of it.
Right. But do
Let me
you
see.
think that they're actually responsible for anything that had to do with if these photos were the same photos that were out there before, then why are they being used at this point? That's kind of my whole question. Is I feel like there's like multiple leaks, and even if this leak is genuine and real, which I don't even know what it is that he took pictures of, because in his arrest affidavit it states that he took pictures of side-by-side photos.
Yeah, I don't buy that. From
Well, that's what they
there's
found
one
on his
image
phone.
that is right. That is right. But the thing is that the email or the message exchanges, what I got from Mark and Fortune is that Fortune wanted to send Mark crime scene photos without sending him it. So he devised a plan to get on, well, I guess his phone and maybe have like a second phone and take images of that. And that is what we kind of see in Snay, his elaboration of the crime scene photos, because it looks like it was taken from a screen. And that would make sense if Fortune really did that. And that's the hella confusing thing about this entire part, because Baldwin's statement in the in-chamber hearings was that Mark was also corresponding with somebody that he said that he got the crime scene photos from a disgruntled cop.
Yes. And then he told Skip that he was getting crime scene photos that the we aren't ready to leak yet. There was a quote unquote we there, and he was getting those from somebody who was promised a 9-to-5 job that didn't get the 9-to-5 job, and so they were disgruntled. Well, that's not going to be Thomas. Thomas wasn't going to be offered some cushy 9-to-5 job. Being the sheriff isn't a 9-to-5 job, and wouldn't think it's very cushy.
Deputy sheriff. That was the offer that was being made. If you would, in essence, the leak that we talked about is because Mike Thomas losing the primaries, and after that, releasing those documents just out of sheer spite, because, well, they wanted to devise a plan for him not winning the elections. And from my understanding, he was pretty well off. I mean, he was a pretty smart guy. Yeah, he was already deputy sheriff, but he was being promised that as well.
But I don't know how he
And
would be promised the job that he has, and when he's actually fighting for a promotion that's even a harder job.
well, see, the thing is, back in 2017, from what I got, if I even got it clear, but in essence, in 2017, he was part of the investigation in the beginning, but he got kicked out because he had different opinions with, well, the investigator that were part of the homicide team. See, just because you were a sheriff or a deputy sheriff, that does not automatically mean that you're a homicide detective. I mean, let me be clear on that one. But he had a different view on the investigation. From what I got, he thought that Ron Logan did it. And that kind of like spiraled through the years. And due to this primary election back in 2020, and him being demoted to work back on the streets is, yeah, kind of like this conspiracy that has been flourishing, basically. And there is a timeline, though, between this all occur. We all know that from what I got from Mark, and I'm citing Mark a lot because I'm the one that pretty thoroughly interrogated him. I didn't take any crap from him, trust me. I didn't tell him that he was a nice guy. I think he's kind of a DICK. He manipulates, I know that. But
Mhm.
I was willing to talk with this guy to see what he knew. So
I think
I
that's
come
fair. I think a lot of people have wondered why he doesn't just come out. If all this guy did was get pictures sent to him by Robert Fortson that he didn't ask for, and he contacts Murder Sheet because he's such a good guy, and he's like, holy crap, I don't know what to do. This dude just sent me these photos, and that's it. Why in the world does he not just come out and say, hey, I just got sent these photos from this guy. I didn't know him that well. I just met him on Reddit. He sent me these photos. I wanted to contact the police, and so I contacted Murder Sheet. That's a simple. I mean, if that's what happened, it's a very simple conversation. It's so much more complex, which is exactly why he doesn't come out and talk.
See, and that is kind of the complex scenario that we're having. Is that well, you had an interview with Skip, and that other name I'm not even going to say, but you had an interview with Skip, and he said that the earliest conversation that he had with Mark was September 12th, something like that, and
It
it
was
was
in September,
entire.
yeah.
Yeah, that was kind of like the entire leaker thing that was going on. But Mark knew specifically a lot about the crime scene, like the footprints that has never been released. Turns out to be true, and a lot more things. And I'm talking footprints as in like plural, not singular. And a lot more stuff that has not been brought out there. And to be honest, I'm still vetting that, so I cannot really. It's useless to talk about because if I cannot confirm it, then yeah, it's kind of pointless. And I say a lot of things on my own stream, but for your sanity's sake, I will keep with the vetted stuff. But there's like a multitude of people that are involved with leaks, and especially Chris Todd. I mean, for the people that did not see the Core TV segment, I could see Bob Mata his head explode when Chris was on.
Bob
So
did a
all
good
kudos
job.
to
Bob did a good job
yeah.
being on there with a bunch of people who are more opposite and think completely different. He does a good job with
Mhm.
maintaining that.
Yeah, true. I mean, and we definitely need those people that keep that sanity. I mean, Bob is a defense lawyer and he does a really good job, and I give him a lot of crap for it because I was like, dude, why won't you listen? This is what I hear. But that is fine because he thinks in his own terminology, and that's good. Um, However, yeah, I talk to a lot of interesting people, and I do not think that I have a 100% source, but these people tend to have a lot of information of search warrants, and that's kind of like spitting through the, or yeah, spitting is like
Right.
digging in Dutch, by the way. Just okay, go ahead.
Like
Go
digging
ahead.
through.
Yeah, digging through.
Well, so I think that Mark manipulated and tried to get in with anybody who potentially had information. And so what he did was take it to who at the time became somebody who was getting information, which was Murder Sheet. And so he needed to get in with them. And
Yeah.
so he needed to provide information also, because otherwise they're not going to have any use for him, right? I mean, there had to be some type of quid pro quo. So he gets all this information, he's gathering it from different places, so he becomes a central source of all the information that ends up leaked. And whether he's the quote unquote original leaker or not, the important piece is he's the one that's spreading and intentionally going in and trying to find the information to give it to a type of murder sheet. And remember, when he talked with Skip, he was trying to get Skip to hook him up with these podcasters. That was his whole intention with talking to Skip, because Skip was going on True Crime Garage and a few of the YouTubers that were really into Delphi at that time and knew Murder Sheet. So he was trying to get Skip to hook him up to give this information. Now, why? Who? My question and what I want to know from Mark is who's pushing this agenda for him to go out and disseminate the information. That's the important piece. If that was out there, nobody would give two shits about Mark.
Maybe it's somebody that used to work for the New York Times.
But I see that there's still a point there. Like, how is he getting the information? Even if that is true, which I do almost feel like it's opposite, though. I feel like Mark's feeding them the information, not vice versa. But that's just me.
What I got from this individual is that he's heavily active on, I guess on Discord. And, you know, I talked to this individual and he gave me, quite some lines. And, you know, in this case, let's be honest, Teresa, I mean, you cannot trust anybody. I totally get that.
I don't.
Good. But the fact of the matter is that he says that Mark only showed it to 2 people. And I'm pretty sure I talked to one of them. They confirmed it. And
I don't believe
one
that.
I'm pretty sure as
Not
well.
that you didn't talk to them. I don't believe that he only shared it with 2 people. I think that's a lie.
You tell me. But from what I am now getting is that Mark did distribute them to people that do not think Richard Allen is innocent, but Richard Allen is guilty.
I agree with you. That was the big narrative they tried to push, was like, look at all the people who got the photos are all the ones who think that Richard Allen is innocent. And it's like, wait a minute. No. If we actually go through the people that we know have seen the photos or were the first to come forward saying they saw the photos, the majority of them, outside of Snay, which is why I'm telling you, I think that Snay was their debacle. Snay was their demise, because it was everybody who actually thought that Richard Allen was guilty that had the photos. And as soon as they were sent to Snay, shit hit the fan.
Boom. Yeah.
Because everybody else
for that. I have to be honest.
Yeah, everybody else thinks that, you know, all those other people that are involved in this are all pro Richard Allen's the guy. And not that I don't like them as creators, because I don't care what they think. I don't care if they think he's the guy or not. But let's be real. They all think he's the guy, and those are the ones who had the photos.
Yeah. That's the fact.
And then somehow True Crime Design got it. She doesn't think that, but, you know.
No clue how she got it. But, hey, she got them.
But they were already out there, so they were being disseminated from these people out to other people by them. I know now they're down the chain. It doesn't matter. Right.
True.
So I think the original... What? What's true?
I was just agreeing with you.
Oh, sorry. I thought you were reading something in chat. I was like, wait a minute, I'll highlight it. So I think that all the people who originally got them knew that he, or thought that he was guilty, and then they got out to people who didn't think he was guilty, and that's how we ended up here.
Yeah, that's kind of an essence, but I'm at least happy that we got that cleared up, because it was hella confusing. And let me see.
So I have to ask you, are you at the point where you actually think he's the guy, or do you still go back and forth? Do you change your mind all the time?
No, I still think he's the guy.
What makes you think he is the guy? What is the one, if you had to say, this is it, this is why, what is it?
I think it's really strange that the guy had a single bullet in a plastic bag in a wooden strongbox.
Why?
Memorandum. I do a lot of stuff about serial killers, so I do a lot of criminal profiling as well, and I think that's a memorandum. Memorial, if you would to think.
So you think that he actually spent 2 bullets, and that he kept one and left one there?
Yeah.
Let me see if this is the right one. Nope, that's not what I want. It's this one.
Oh, you were waiting for me to say that, wouldn't you?
No, I actually saw it yesterday, so it's still up. So this is not in a plastic bag. Just want to let you know that this is the sealed plastic bag is what they put it in, and it's how it's received into evidence. So everything here is in a plastic bag or a paper bag, depending. If it has DNA on it, it needs to be in paper. And if it doesn't, if they're not looking for DNA, it can be in plastic. But everything here is put into something. So the 40 caliber S&W cartridge found in the wooden keepsake box on the dresser between both closets in the master bedroom. It wasn't actually in a bag. It was just in there. So I don't know if that changes anything for you, but I just wanted to
no. It's still the same. I was just like remembering what it was in.
Yeah, you're remembering it verbatim how it was said.
Yeah, verbatim. Yeah. But don't
So
you think that's odd?
what do you think that actually? What do you think that means?
I think, see, there is nothing that physically connects Alan to the crime scene. For me, this is kind of it.
It's the bullet.
But yeah, and then the bullet. You know, it for me it attaches the crime scene to him. I know it doesn't say anything, but it's, I guess, like a psychological thing, I guess.
So if there was no bullet found at the scene, or if somebody proves that bullet actually didn't come from his gun, then what do you think?
Then it wouldn't mean anything.
So what would happen if an expert gets on the stand and proves that this did not come from this gun, that it could have come from this gun? Like, what if there's like a Perry Mason moment that happens, and all of a sudden they're like, "You think it came from this gun?" And they're like, "Oh, well, he's like he was a big lawyer." I know. He was a big lawyer on TV, and he always had like these moments that, like, in court, which never really happen in real life. That, you know, it would come in with like explosive evidence. Okay, so I'll rephrase and I'll ask it a different way. If for whatever reason the motion in limine or the suppression hearing happened and the bullet was never even going to make it to trial, or there is no chain of custody, like is rumored from the memorandum, if it never makes it there, what happens with the case?
Well, in all honesty, I always had kind of a serial killer vibe just by the sheer nature of how these two girls were brutally murdered. And that is mostly because of the pristine way how they got murdered. And we didn't know anything until now, but I always got kind of that sense because Robert Ives said there were signatures, and not one, not two, but at least three. And he was talking about serial killers as well. And, you know, it's not really necessarily a study or whatever, but I guess I love patterns. And people do. I used to work in mental health, and I worked a lot with autistic kids and adults as well. And they heavily attach to certain objects. Now, if you were to not have the ability to, for example, make a photograph or whatever, a serial killer, for me at least, would, if they were to take a trophy, and a lot of serial killers did take trophies, took hairs, etc. I mean, you know, the entire ordeal. I would think it wouldn't be an unlogical thought, at least for me, with this perception of him being a serial killer. And I don't know, but I was going from that aspect, right? From him having a trophy of, well, we know that two parts of clothing are missing. A regular killer rarely does that in percentage, basically.
And they didn't find those articles of clothing at his house.
True, but now in hindsight, there are multiple people apparently involved.
So you think that he's involved, but could potentially be part of a bigger crew of something that happened? There's a lot of people who think that.
If you think about it, I mean, the prosecution certainly thinks that.
Well, they did. I don't know if they do anymore.
I'm pretty sure that they still do. But if you just listen to Doug Carter saying persons multiple times in the press conference, he didn't use it singular. He used it multiple times. And that's why I was citing each time to the interview that I did with Eric, is that I find it highly fascinating that he got sent away on the wrong side of the bridge. Nobody was searching there.
Right.
I cannot help it that it bothered me.
It was a good interview you guys did. Well, he gets turned
But
away, but here's another ironic thing about the fact that he got turned away and was told not to go any further was that other people were actually still out there. And if you listen, then Mike Patty was still out there searching. So why couldn't Eric be out there?
Yeah, you tell me. And maybe
I
that
wish I
is
could.
why they're maybe that is why they're thinking multiple people are involved. I don't know.
So where are you at with the leaks? What's your final thought on that? Where are we at?
I think the leaks are kind of a cluster F in the sense of not not having necessarily to do with what Westerman is saying.
So do you think that anybody in the public has actually seen the pictures that Mitch Westerman took in supposedly August? Do you think that those have ever come out to the public?
Well, it depends how he's describing them. No.
So you think that the
think he's
crime scene
lying.
photos that are out there now are the same ones that have been floating around for at least a year?
100%.
I agree.
Because see,
All right.
no matter the one that I sent you, the partial one, does it look like it was taken from a camera or a photo, a phone?
No. And from my understanding, the photos are different sizes.
Mm-hmm.
So they've been cropped and done all kinds of stuff to them before they've ever even reached the point where we're at now.
Now,
Southern Sweet Tea, that's a very good point too. The
fair
whole case
enough.
is a cluster.
But now, in essence, there is this also this other rumor that the photos were taken by the 13th of October. What is significant on that date? Search warrant of Richard Allen, the first one. Well, the first one, and that photos got taken. Yeah, I guess from his house. That is the argument, and I'm not sure, but that the leak.
I don't
came
know,
from
because
there.
if you believe that the depositions taken by Holman, Liggett, and them, there is nothing electronically that connects Richard Allen to the scene. So then that would not mean that there was any photos on those phones, even though there's like 13 photos.
Maybe
Or
like,
laptop,
I don't
or
know.
any type of electronic.
True, what I get
no.
you. Yeah, I'm just relating it out there. I'm not sure what to think of it, but yeah, I guess that is it on the leak. I mean, I wish I could tell you guys more, but unfortunately, still digging into it, and believe me, it's getting tiring.
I know, I get it, and I get that people are kind of over the whole leak thing because it's just so confusing, and
Yeah.
it just kind of fits the whole pattern of this case to begin with, like you guys are saying, like it's just a cluster. So, but I'm gonna actually end up wrapping it up, so that I can go and do Christmas shopping with the kiddo. You probably need to go to bed.
Thank you, Mom.
It's like, isn't it like midnight? And what time is it there? I think it's like middle of the night there because it's so dark here. It has to be like really late there.
No, I still have an hour to go because I need to watch somebody else. But
okay, all right. Well, thank you for coming up, Frank.
You.
I appreciate it. All right, you guys. So, final thoughts. What do you guys think? I thought Cara did a great job. I think she made some really valid points. And maybe I feel that way just because I already agree with her anyway. That's where my mind is. And so she's kind of agreeing with me and I'm agreeing with her. So maybe that's why I do think she's kind of a badass. It's always interesting to me to go and listen to those that are completely opposite and then try to figure out how they feel the way that they do. That's where I'm kind of at with it. So I want to see what the others. I don't know if it's another side because I don't really have a side. So it's like maybe I don't know. Maybe I am more towards the not guilty side, but that's not true because then sometimes I'm like, dude, I really think this probably is the right guy. So I don't know. I don't have a side, but you know what I mean. The ones that are so far to the guilty side. I want to go listen to them and see what they have to say. And then I also am very interested in what the ones who think he's innocent say. But I think they're going to be more on the same page as me. So she says, I think Cara did a great job. I do. I think she did. Yeah, I don't know. That's why I'm like, I don't know. Depending on what day you ask me, I think. JD Coop. I like to be kind. I like kindness. I like listening to people's thoughts. I like to see where people are at and see, you know, what they're thinking. And I honestly, I'm very curious about the people who are so firm that that they think he's guilty. I like to know what's the piece that puts them over. What's the piece that pushed you over the fence? And maybe they're going to have a piece that I don't have, which I don't know if it can happen, but maybe they do, and they can push me there too. And then I can let this go, and I can be like, all right, well, once the Supreme Court's done, then I can just go back to covering all the cases. Because right now I'm stuck, you guys. If you look at my channel, all of a sudden it's turned into Delphi, and I'm like, this is not, I like all cases, and I'm just stuck here. If we only spoke to one side, then that's not good investigative skills. That's true. Logan did. Logan and BG did. I appreciate you guys. Thank you guys for hanging out with me on this lovely Thursday. Go enjoy the rest of your day. And if we do not hear from the Supreme Court tomorrow, I think that Mr. Bob Mata is going to be joining me. If we do hear from the Supreme Court, then I think we're going to be doing separate lives, but we'll see. If otherwise, come back tomorrow and we'll have Mr. Mata on with us to give us his legalese insights. I'm excited about that. Bob should be live as of 7 minutes ago. So I don't know how to do any of that rerouting stuff, which I know people can do, but I don't know how to do it. Let me see if I can just pull up his live real quick, and then I can just give you guys the link if you're not subscribed. He should be live. He's not quite live yet, but it'll be a good live. So, and then if you guys are, any of you guys are interested in the Watts case, one of my besties on this platform, ATS News, is going to be going live. I think it's episode 4. I know she probably hates me for it, but I can't go back to Watts. I just can't do it. But I know tons of people are watching, and she's going back through all of the Watts stuff. So make sure you guys hit up ATS News. I'll give you guys her link too. If you guys want to go back down the Watts trail, she's probably one of the best that you're going to get the info from, in my personal opinion. And she's live. She should be live. I'll find out right now when she's live. She's going to be live in about 22 minutes. And then tomorrow, I think she's going to do some Delphi after I do. I'll get you guys that link. I just put Bob's in there. So you guys should be able to get to Bob. And then anybody who loves the Watts, who's still stuck on that and just can't wrap their mind around it, or anybody who wants to learn about it even, that's even better, because she's going back to the beginning. So if something was, you know, somebody was like, hey, I missed all the Watts stuff and I got here after that, definitely go check out ATS News. Go have a blessed Thursday. I appreciate each of you guys for being here, and I will see you on somebody's channel later on. Have a good one.